All right. Good morning and welcome to a regular meeting of a panel of utility commissioners and staff of the Public Utilities Regulatory Authority held today, Wednesday, December 10th, 2025 at 9 a.m. by remote teleconference. My name is Tom Wheel and I'm the interim chairman of the authority. I'm joined today by my esteemed colleagues, Vice Chairman David Arconti, Interim Commissioner Jan Beecher, and Interim Commissioner Holly Cheeseman. Commissioner Michael Carrion is not able to be present for today's meeting, but he did ask me to send his regards. We have a regular calendar and two consent calendar items on the agenda today. We will first turn to section A, which is the regular calendar. And I want to just start with a quick correction. We're going to remove item 4 from this section of the agenda, which is a decision in docket number 250510, application of sustainable energy services for a Connecticut electric aggregator certificate of registration. We won't be taking action on that item in today's meeting. Um, so with that, we'll move first to item number 1, which is docket 220701 REO1, application of Aquarian Water Company of Connecticut to amend its rate schedule, remand. And we will turn to authority staff to present the decision for the panel's consideration. I believe that is Attorney Bowman.
Thank you, and good morning, Chairman Wheel, Vice Chairman Arcani, Commissioner Beecher, and Commissioner Cheeseman. On August 26, 2022, the Aquarian Water Company, Aquarian or Company, filed an application to amend its existing rate schedules pursuant to General Statute Section 16-19. On March 15, 2023, the authority issued its final decision in the corresponding docket, number 22-07-01. The company subsequently filed an administrative appeal of the final decision with the Superior Court on March 30th, 2023. And then on March 25th, 2024, the Superior Court largely affirmed the authority's final decision. Specifically, the Superior Court dismissed 9 of 12 counts in whole, another in part, and remanded 3 issues to the authority for further proceedings consistent with the decision's provisions. The authority reopened this rate case and addressed the 3 issues remanded by the Superior Court in a decision issued on July 21st, 2024, in docket number 220701 REO1. The company appealed the Superior Court decision to the Connecticut Appellate Court, but the Connecticut Supreme Court transferred the matter to itself. On appeal, the Supreme Court upheld the Superior Court's decision with one exception regarding the authority's rejection of Aquarian's request to recover an additional $1,498,050 in deferred conservation expenses. On that single issue, the Supreme Court remanded the case back to the Superior Court with direction to remand the case to the authority for further proceedings. This supplemental decision addresses the remanded deferred conservation expenses issue. The history of cost recovery for water conservation measures is important to the resolution of the issue on remand. Public Act number 13-78, an act concerning water infrastructure and conservation, municipal reporting requirements, and unpaid utility accounts at multifamily dwellings, required PURA to identify water and energy conservation programs that would be eligible for recovery by any water company in a general rate case, provided that water companies implement them and demonstrate that the expenses for such programs were reasonable and prudent. In response, in 2013, the authority initiated docket number 13-08-16, PURA investigation of water and energy conservation programs eligible for cost recovery during general rate case, which resulted in the authority's July 6, 2016 conservation eligibility decision. In that decision, rather than pre-select specific programs for inclusion or exclusion from cost recovery, the authority established a cost-effectiveness standard for evaluating such programs. Specifically, the authority specified that utilities are free to develop any program for rate consideration that is cost-effective. That is, annual savings in typical rate case expenses, such as electric bills, water treatment, and transportation costs, must exceed annual program costs. In applying the Conservation Eligibilities Decision Standard to Aquarian's August 22, 2022 rate amendment application, the authority erroneously applied the latter sentence of the Conservation Eligibility Decisions test in a literal fashion, assessing whether the post hoc quantified savings from avoided expenses exceeded the company's actual cost of implementing its conservation initiatives. In so doing, the authority approved only 50% of the company's deferred conservation expense request because the company could not substantiate any savings beyond the approximately 1.5 million in documented variable cost savings, such as reductions in chemical and power costs associated with decreased water usage. Additionally, the lack of documented specific conservation goals or key performance indicators meant that the company had no other way of meaningfully assessing its conservation programs. The Supreme Court found that the authority's reliance on post-implementation cost savings to constitute an impermissible hindsight analysis. In accordance with the Supreme Court's decision, the authority reconsidered the company's request for recovery of all deferred conservation expenses to include, in the present context, applying the conservation eligibility decision's cost-effectiveness standard as read through the lens of the prohibition against hindsight analysis. Viewed through that lens, prudent water companies should not commence or continue a specific water conservation measure unless it is reasonably expected to have a net positive cost benefit at the time the decision to undertake or continue a conservation program is made. Upon review, record evidence supports a finding that the company reasonably expected its water conservation efforts to result in overall cost savings at the time they were initiated. Prudent management, however, also includes a continuing obligation to periodically assess the effectiveness of conservation programs. While the record does not contain evidence of any systematic review of Aquarion's conservation program against robust company-established goals and key performance indicators, given the confusion concerning application of the conservation eligibility decision's cost-effectiveness standard, the authority, in its discretion, finds all documented deferred conservation costs prudently incurred. Similarly, upon balancing the factors set forth in General Statute Section 16-19E, subsection A, the authority finds that the claimed deferred conservation costs are just and reasonable because, among other reasons, the costs cover the legitimate operating costs of the company and because they advance state policies intended to encourage and support water conservation. Accordingly, in this supplemental decision, the authority approves recovery of an additional $1,498,050 in deferred conservation expenses. The authority adjusts Aquarion's approved operations and maintenance expenses in the amount of $249,675 based on a 6-year amortization of the additional $1,498,050, with carrying costs to be computed at the company's weighted average cost of capital. Authority staff respectfully recommend this supplemental decision on remand for adoption.
Thank you very much, Attorney Bowman. Is there a motion?
Mr. Chair, I move adoption.
Second.
Thank you. The decision has been regularly moved and seconded, and we will move to any comments from commissioners, starting with my own. I'm going to say this comment a couple of times today, or variations of it. I issued correspondence in this docket on December 3rd, 2025, notifying parties that I have recused myself due to my participation in both the underlying proceeding as an attorney for the Office of Consumer Counsel, that is docket 220701, as well as my participation in the appellate proceedings that ultimately culminated in this remand. For that reason, I will abstain from today's vote. I'll pause for any other comments from commissioners. Hearing none, Mr. Bumpin, could you please take the roll?
Vice Chairman Arconti,
Yes.
Commissioner Beecher,
Yes.
Commissioner Karen, Commissioner Cheeseman.
Yes.
Thank you. That decision has been adopted. And we will move now to item 2 on section A of the agenda, which is docket 241205, PURA procedural review of the annual rate adjustment mechanisms of the Connecticut Light and Power Company and the United Illuminating Company. And authority staff, it can please present that decision for the panel's consideration. I believe that is Mr. Norton.
Yes, good morning. Good morning, Chairman, Vice Chairman, and Commissioners. In this proceeding, the Public Utilities Regulatory Authority examined potential procedural changes to the Connecticut Light and Power Companies, or Eversources, and the United Illuminating Companies, or UI, collectively the EDCs, rate adjustment mechanisms, also known as RAM. The authority primarily aimed to examine potential changes to cost allocation methodologies, the treatment of uncollectible expenses, and the drivers of and mitigation strategies for significant over or under recoveries within the RAM. This decision establishes the structure for future incorporation of the partially actualized and partially forecasted net cost effects of the embedded power purchase agreements, or PPAs, within the non-bypassable federally mandated congestion charge, or NBFMCC, as a result of the locational marginal price, also known as LMP, fluctuations within the wholesale energy market. LMP fluctuations have been a significant driver of rate volatility experienced by customers in recent years. Additionally, the authority establishes a two-step analysis for the EDCs to monitor the net cost fluctuations of such PPAs on a monthly basis, and provides an avenue for rates to be adjusted between the 4 currently scheduled standard service and RAM rate adjustments to mitigate the impacts of any significant swings in the wholesale market for electricity. Additionally, this decision provides structure for the authority to consider the potential future implementation of cost allocation changes to the NBFMCC and System Benefits Charge, also known as the SBC, within the 2026 annual RAM review proceedings. More specifically, in this coming year's RAM review proceedings, the authority will further consider adoption of a 12 coincident peak and energy cost allocator for the various costs within the NBFMCC mechanism for both EDCs, as well as consider adoption of an energy allocator for Eversource's SBC mechanism. Importantly, nothing within this present decision will have any impact on current electricity rates. The determinations in this decision reflect the invaluable input from the participants throughout this docket, which will now enable the authority to more easily finalize and implement process improvements within the 2026 RAM review process. Lastly, this decision directs the EDCs to provide alternate calculations for the treatment of non-hardship uncollectible expenses in the 2026 RAM, so that the authority may further investigate alternative allocations for such expenses prior to each company's next rate case. The authority recommends the decision for approval. Thank you.
Thank you, Mr. Norton. Is there a motion?
Mr. Chair, I move adoption.
Second.
Thank you. The decision has been regularly moved and seconded. I'll again turn to hear commissioner comments, again starting with my own. I issued correspondence in this docket on October 21st, 2025, notifying docket participants that I had recused myself due to my participation in this proceeding on behalf of the Office of Consumer Counsel. For that reason, I appreciate Mr. Norton's appreciation of the input of the participants to this proceeding. And for that reason, I will abstain from today's vote. I'll pause for any other comments from commissioners.
I have a couple, Mr. Chair, if you don't mind.
Sure.
Thanks. Just first want to commend Mr. Norton and all of our staff on their work on this docket. This hasn't garnered a ton of attention, but I think it's an extremely important decision that we're coming to here today. This decision incorporates proposals from both utilities and DEEP and OCC, which I think makes it a well-rounded decision. And as Mr. Norton mentioned, its aim is to create procedural measures to smooth out any potential rate shocks for customers in the future, because neither PURA, the utilities, or anyone else here can fix the markets or predict with perfect accuracy the direction that LMPs will go in. But I think the procedures we're putting in place in this decision will greatly help in the authorities' deliberations on future RAM proceedings. So I thank everyone's work that went into this over this past year, and I will be supporting. Thank you, Mr. Chair.
Thank you. Any other comments? Okay, hearing none. Mr. Bumpin, could you please take the roll?
Vice Chairman Arconti,
Yes.
Commissioner Beecher,
Yes.
Commissioner Karen, Commissioner Cheeseman.
Yes.
Thank you. That decision has been adopted. We will move to item number 3 now, which is docket number 250217, application of MPN Capital Markets US Incorporated for a Connecticut Electric Aggregator Certificate of Registration. Authority staff could now present that decision for the panel's consideration. I believe that is Attorney Elizabeth Tanaka.
Good morning, Chairman Wheel, Vice Chairman Arconti, Commissioner Beecher, and Commissioner Cheeseman. On February 21st, 2025, MPN Capital Markets US Incorporated, or MPN, submitted an application to the authority requesting an electric aggregator certificate of registration pursuant to General Statute 16-245. In this decision, the authority finds that MPN fails to qualify for an electric aggregator certificate of registration because MPN acts as a supplier's agent pursuant to General Statute 16-245. Subsection H, subsection 1. MPN has ongoing contracts and compensation agreements with suppliers, which indicate third-party agency relationships. An electric aggregator is defined as an entity that gathers together electric customers for the purpose of negotiating the purchase of electric generation services from an electric supplier. An aggregator may not be a supplier or an agent of a supplier, and an aggregator must act on behalf of the electric customer. Therefore, the company does not qualify as an electric aggregator. Thank you for your consideration.
Thank you, Attorney Tanaka. Is there a motion?
Mr. Chair, I move adoption.
Second.
Thank you. The decision has been regularly moved and seconded. I will pause for any commissioner comments. I don't have any on this one. Thank you. Mr. Bumpin, could you please take the roll?
Chairman Wheel,
Yes.
Vice Chairman Arconti,
Yes.
Commissioner Beecher,
Yes.
Commissioner Karen, Commissioner Cheeseman.
Yes.
Thank you. That decision has been adopted. As I indicated earlier, we're removing item 4 from today's calendar, so we will next move to item 5 in section A, which is docket 250808, non-wire solutions process cycle 1, the screening decision. And authority staff, could you please present the decision for the authority's consideration?
Yes. Good morning, Chairman Wheel, Vice Chairman Arconti, Commissioner Beecher, and Commissioner Cheeseman. The authority initiated this proceeding on January 17th, 2025 to serve as the administrative record of the first non-wire solutions process cycle. The non-wire solutions process is a transparent and competitive mechanism designed to evaluate alternatives to traditional distribution system capacity upgrades and other utility expenses. On February 7th, 2025, Eversource Energy and the United Illuminating Company, or UI, submitted the annual data filings and the grid needs filings, which is the first step of the non-wire solutions process. The data filing provides system data, financial data, and distributed energy resource deployment data. The grid needs filing contains utility-identified distribution system needs in 2 documents. A summary document, which sorts the grid needs as either likely, potential, or unlikely NWS opportunities, and a narrative document, which provides more information and analysis substantiating the summary document. For each grid need, the utilities evaluate whether a non-wire solution is a feasible alternative to the traditional solution and recommend whether there should be a competitive solicitation. In this year's annual filings, Eversource and UI did not recommend any grid needs for a competitive solicitation. On June 27th, 2025, the Process Monitor, which is a consultant hired by the authority to administer and oversee the process, filed its first set of comments on the EDC data and grid needs filings. On August 22nd, 2025, the Process Monitor submitted a second set of comments on the filings. The Process Monitor did not recommend any of UI's grid needs for a competitive solicitation, but it did identify one Eversource project related to the upgrade of the West Brookfield substation as a potential NWS opportunity. This decision is the PURA screening decision for the first process cycle. The screening decision evaluates the EDC's recommendations and the Process Monitor's comments and selects the grid needs that should be subject to a competitive solicitation because there is an opportunity to procure a beneficial non-wire solution that defers or avoids a traditional distribution system upgrade. The authority accepts UI's and the process monitor's recommendation that none of the company's grid needs should be subject to a competitive solicitation. Regarding Eversource's grid needs filing, the authority determines that the transformer replacement project at the West Brookfield substation is a valid opportunity to conduct a competitive solicitation and potentially procure an alternative solution. However, Eversource has raised legitimate concerns that the project has a relatively near-term time of need date, and according to the company's assessment, that a non-wires alternative is unlikely to be cost beneficial compared to the traditional solution. Eversource's concerns are reasonable, and the authority clarifies in this decision that it is ultimately Eversource's choice as to whether or not to conduct a competitive solicitation. In recognition that this is the first NWS process cycle, the authority also recommends several areas where NWS program implementation and effectiveness could be improved. These include further process to develop clear expectations around the format and contents of the annual filings, establishing documentation criteria and accepted practices for evaluating the feasibility of alternatives to traditional solutions, and providing more context on how the grid needs in the annual filings fit into each company's broader capital plan. Thank you for your attention, Commissioners. Authority staff recommend this decision to the panel for adoption.
Thank you very much, Mr. Butler. Is there a motion?
Mr. Chair, I move adoption.
Second.
Thank you. The decision has been regularly moved and seconded. Again, I have a comment on this docket similar to my other comments. I issued correspondence in this docket on October 21st, 2025, notifying participants that I recused myself due to my involvement in this same proceeding on behalf of the Office of Consumer Counsel. I do want to emphasize today I was involved in the development of this program dating back to 2020 and docket 17-1203 RE07 and all the way through my time at the Office of Consumer Counsel. But for clarification, I'm recusing myself from this proceeding specifically because I engaged in stakeholder meetings within this proceeding. I do not intend to recuse myself from anything having anything to do with this program. I just wanted to say that for clarification. And for that reason, I will abstain from today's vote. Are there any other comments from commissioners?
I just have a couple. Yep.
Sure.
Thank you, Mr. Chair. Again, just want to commend Mr. Butler on all his work and other lead staff on this docket. As Mr. Butler mentioned, it is year one, so always having to work things out. And I think the recommendations for further improvement in the process and the final decision are worthwhile, and looking forward to see the next iteration of this. And as always, the panel of commissioners always takes seriously and reads through all written exceptions for each and every docket before we enter into a final decision. And I think this decision really shows that we take written exceptions seriously and will make adjustments as needed. So thank you for the indulgences this morning, Mr. Chair, and I will be supporting the final decision.
Thank you. Any other comments? Hearing none, Mr. Bumpin, could you please take the roll?
Vice Chairman Arconti,
Yes.
Commissioner Beecher,
Yes.
Commissioner Karen, Commissioner Cheeseman.
Yes.
Thank you. That decision has been adopted. Okay, we're going to move to section B of the agenda, which is a list of 80 dockets. This may be a record for PURA. 80 dockets for which the applicable panels will designate hearing officers or presiding officers. The majority of dockets on this list were opened prior to the authority adopting the practice of doing these designations in our regular meetings. Just for information, that speaks to the volume of dockets in this portion of the agenda. I do have another second correction to the agenda to make here. Item number 55, which is docket number 250703. The agenda proposes that the panel designate me as presiding officer. That is an error, and that item number 55 should instead propose that the panel designate Staff Attorney Elizabeth Tanaka as a hearing officer for this docket. So with that correction in mind, is there a motion for this section of the agenda?
Move adoption.
Second.
Thank you. Items number 1 through 80 on this section of the agenda have been moved and seconded. Mr. Bumpin, could you please take the roll?
Chairman Wheel,
Yes.
Vice Chairman Arconti,
Yes.
Commissioner Beecher,
Yes.
Commissioner Karen, Commissioner Cheeseman.
Yes.
Thank you. The panel is assigned to items number 1 through 80 of designated a presiding officer or hearing officer as applicable. And lastly, we'll move on to section C of the agenda, which is another consent calendar for designation of hearing or presiding officers. Again, this is largely a list of dockets that were open prior to the authority's practice of designating presiding or hearing officers in regular meetings. And the reason this section is separated from section B is that I am not a member of the panel of commissioners assigned to any of these dockets, either because I've already recused myself from this proceeding due to my prior involvement with the Office of Consumer Counsel, or I intend to do so in the near future. Because I'm not a member of the panel of commissioners assigned to any of these dockets, I won't participate in the designation of presiding officers in this section of the agenda. Is there a motion for items 1 through 23 in section C?
Mr. Chair, I move adoption.
Second.
Thank you. Items 1 through 23 have been moved and seconded. Mr. Bumpin, could you please take the roll?
Vice Chairman Arconti,
Yes.
Commissioner Beecher,
Yes.
Commissioner Karen, Commissioner Cheeseman.
Yes.
Thank you. The panel is assigned to items 1 through 23 have designated a presiding officer or hearing officer as applicable. That brings us to the end of today's regular meeting agenda. We will adjourn and reconvene next Wednesday, December 17th, 2025 at 9 a.m. via remote teleconference. And please note that that will be the last regular meeting for calendar year 2025. Thank you.